Welcome to Cross Continent Law, where hopefully we're going to be making legal principles, breaking them down into chewable, digestible bits to make more meaning, and so that we can appreciate that actually the law is a tool for social engineering. So on a preliminary note, I want to say that I'm going to start from contract law, and your anchor is Patrick Ikechukwu Ibekwe, PhD. And we're going to be starting out with contract law. And I just wanted to say that on a preliminary note, we're going to be making our discussions. The principles discussed here actually are going to apply. They apply to both civil law system and the common law system, as well as the mixed law system. In any case, the mixed legal systems are a combination of the common and the civilian legal regimes, and as well as some ideological legal principles like socialism. So in a nutshell, what it means is that our discussions here are going to be applying to these three broad categories of legal traditions, as well as maybe one or two others that are based simply on ideologies. Most of these legal systems borrow from one another, and they have a common root in the Roman law. Actually, the Roman law, when it comes to the civilian legal system, is probably the progenitor of the civilian legal system, tracing from the Justinian Code. And the common law draws its roots actually from the Roman Praetor. So whichever way we look at it, it is the Roman law, the Roman legal system that is, as it were, the mother of all legal systems, at least in modern terms. We do know that there are such concepts as the Hammurabi codes, which pre-existed before the Justinian Code. Of course, the Justinian Code came about in about 527 to 565 during the time of the Emperor Justine. Okay, so we're going to start with contract law, as we said. So first, we're going to be asking for what is a contract. A contract to the layman is simply an agreement between two parties or two individuals. That's what a contract will be for a layman. But for a legal definition, we're looking at that type of agreement or that type of interaction or relationship which a court of law will enforce. So we're going straight to the American Law Institute definition, which could be found in Section 1. It says that an agreement, that is a contract, because a contract is basically an agreement or a pact. You see, so a contract or an agreement is a promise or a set of promises which a court of law will enforce the breach of or regard the performance of as a duty on either of the parties who that refuses to perform their own part of the obligation. So we say that a contract, therefore, is an agreement between two or more people which they intend should bind or regulate their future relations, and which they expect that will create legal obligations on all concerned in the courts, and that the courts will recognize and enforce the terms therein. So in other words, we're saying that a contract is an agreement that both parties or parties who are involved in it assume is going to bind their relations, and that if any of the parties refuse or neglect to do their own part of the bargain, then a normal court of law will enforce that agreement against that party. And in breaches, the court will be ready to award damages as a result. So that's what our definition for today is. So we're going to have to continue next time. This is just a preliminary, an introductory lecture, and we're praying that there will be time in the future again when we'll continue. Next, we are going to be looking at the common principles that you look for, or the common ideals that you look for in a normal contract that we've been talking about, that a court of law is going to enforce. We're going to be looking at some principles about contract law, some ingredients, some elements of a contract that a court of law will feel happy enough to enforce. So tomorrow, when we reconvene, we're going to be looking at those principles, beginning from the capacity to enter into such an agreement in the first place. That is, do you have the capacity to contract or not? That is the next thing we're going to be looking at on this forum. Remember, I'm speaking to you from Cross Continent Law, and my name again is Patrick Ikechukwu Ibekwe, PhD. See you again on the rebound. Thanks very much. Bye-bye, bye-bye, bye-bye.